Students with exceptionalities and their families have struggled for many years to achieve acceptance, inclusion, and access to an education. Today, I would like to offer a brief summary of the history of special education law. A free education is frequently assumed to be a right by virtue of living in the United States and granted by the United States Constitution. However, this is a misconception. The 10th Amendment to the U.S. Constitution states that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Because education is not addressed in the Constitution, it therefore falls to the state. Compulsory or required attendance began centuries ago as early as ancient Judea. However, the first state in the United States to ratify a compulsory school attendance law was Massachusetts in 1952. By 1918, every state had an attendance law in place. Unfortunately, these laws were not inclusive. The state statutes frequently did not encompass African Americans and children with disabilities. Plessy v. Ferguson, 1896, was a landmark Supreme Court case that set the stage for equal but separate opportunities. Mr. Plessy, an African American man, purchased a ticket for the train car appointed for whites only. He was arrested, and his case went all the way to the U.S. Supreme Court. The court upheld the state of Louisiana's ruling that Mr. Plessy was in the wrong. While the case was not based on education, it ultimately had an overwhelming impact on equality in education, as seen many years later in the Brown v. Board of Education case of 1954. A young girl named Linda Brown wanted to attend the whites-only elementary school in her neighborhood, but had to walk 6 blocks each way to attend the school for African Americans. This landmark court case was based on the idea that segregated schools were not and could not be equal to one another. The family believed that school segregation violated their rights as stated in the 14th Amendment of the U.S. Constitution. Chief Justice Warren stated, "We conclude that the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." The Brown v. Board of Education case was instrumental in effecting changes for minorities, and it opened the door for educational changes for children with disabilities. In the years that followed, many small but significant decisions were declared, battles won, and laws enacted. These due in part to parent advocacy and persistence. One very significant court case in 1972 was Pennsylvania Association for Retarded Citizens, or PARC, versus Commonwealth of Pennsylvania. This court case was based on the admission of retarded children from a free public education. The Pennsylvania state constitution stipulated that children between 6 and 21 years of age are eligible to attend a Pennsylvania public school. However, there were found to be several technicalities that allowed schools to reject children with exceptionalities. These loopholes were used to remove or reject children with special needs from attending school. Park versus Pennsylvania declared that school districts deprived special needs children of their rights and discriminated against their parents. Following Park versus Commonwealth of Pennsylvania, in the same year, another landmark court case impacted special education law, Mills versus Board of Education of the District of Columbia. The case was brought on behalf of children with physical, mental, and emotional exceptionalities and alleged that they were being denied a public education. The journey of special education law has been long and difficult. Children with exceptionalities and their families have been the victim of prejudice, rejection, and ignorance. Plessy versus Ferguson, Brown versus Board of Education, Park versus Commonwealth of Pennsylvania, and Mills versus Board of Education of the District of Columbia all made a powerful impact on how special needs children are educated and accepted in the education community. In 1975, the Education for All Handicapped Children Act, or Public Law 94-142, was signed into law. The Public Law 94-142 guaranteed a free, appropriate public education to each child with a disability in every state and locality across the country. These court cases and others have paved the way for the Individuals with Disabilities Education Act, or IDEA. Some of the requirements of IDEA are the public schools must, at a minimum, comply Some of the requirements of IDEA are that public schools must serve children with disabilities, must provide a free, appropriate public education, also known as FERPA, in the least restrictive environment, an individualized education plan or an IEP, and the public school must, at a minimum, comply with all of the provisions within the IDEA. IDEA involves parents in the decision-making processes and obligates the school to assess children in a thorough and timely manner. The public schools must provide students with assistance as they transition from their secondary education to the community. These are just a few of the obligations within IDEA that must be met by public schools. In closing, I would urge you to stay involved in your child's education. You are their best advocate. Stay up to date with special education laws. Access the resources available to you and your child in your community. You can find valuable information and stay up to date on special education laws and resources on the following websites: IDEA Education Week, National Center for Learning Disabilities, and the Alabama Parent Information Center. The information and resources contained in these websites will empower you to be a strong and informed advocate for your child. Thank you.